Now, contracts can be categorized in different ways. First of all, a valid contract. A valid contract is a contract that has all the required elements: offer, acceptance, consideration, capacity, legality. A void contract is an agreement which lacks a required element of a valid contract. So if there was no offer or acceptance or mutual assent, or if there was a failure of consideration, then we call that a void contract. If the contract was for an illegal purpose, the contract is void. Now, the third category is a little bit difficult to understand, and we're going to talk about it more in the context of the sale of goods. But essentially, a voidable contract is an agreement in which one party has the right to cancel what would be an otherwise valid contract. So what if you did own a health club and you entered into a contract with a person who was a minor, and that person fails to pay their monthly dues? You, as the health club, have no right to enforce that promise because the party was a minor. Now, however, on the other hand, if the minor wants to continue with a contract, it may be considered a voidable contract, which means that party, although they have the right to cancel the contract, may instead pursue enforcement of the contract. And if it's a voidable contract, they'll be able to do so. Some contracts may be unenforceable. A valid contract that cannot be enforced by the court because of a legal defense is known as an unenforceable contract. And the best example of this is cases in which the statute of limitations has run. You should be familiar with the concept of a statute of limitations. It's a time period provided by the state that allows parties a certain time in which to bring their claim. And for instance, for a breach of contract claim, in Texas, the statute of limitations for a written contract is 4 years. If you wait more than 4 years before filing your lawsuit, 4 years have passed since the breach, you have lost your right to enforce that contract. The statute of limitations has run, meaning your claim has ended, your ability to bring your claim. Your claim may still exist, the contract was still valid, the failure to perform was there, but you cannot satisfy your expectations because of this rule of the statute of limitations. So that contract becomes an unenforceable contract. Contracts may be classified by contracting system, and we're going to talk about contracting systems in the next lecture. But know that right now in the United States, we have 3 different contracting systems that can apply to a contract. And the first is the common law. This is what you studied in your introductory business law course. The common law governs contracts for services or for real estate. For example, if you enter into an employment agreement, that employment contract is going to be governed by the common law. It's going to follow the rules set forth in the common law. If it is for a rental agreement, again, the contract is going to be governed by the common law. Now, the second contracting system, and the one we will spend our time on in this class, is what's known as the Uniform Commercial Code. And the Uniform Commercial Code is not a law exactly. Instead, it's a model law for states to adopt. And the Uniform Commercial Code governs all contracts for the sale of goods. For the exchange of goods, that's going to be covered by the UCC. The third contracting system that we will touch on is the contracts for the international sale of goods, what we refer to as the CISG, and contracts for the sale of goods between residents of different countries are governed by the CISG. Contracts may also be classified by the level of contractual commitment. For instance, there is a bilateral contract, and this is based on the idea of an exchange of promises. You promise to sell me your computer next Tuesday for $500. I promise to pay you $500 for your computer next Tuesday. That's a promise for a promise, and so we refer to that as a bilateral contract. The other type of contract is a unilateral contract. And in a unilateral contract, one party's legal detriment arises from its action or inaction. In other words, this is a promise for an action. If I say to you, I will pay you $50 if you come to mow my yard. Now, I am bound, right? Because if you show up to mow my yard, then I am obligated to you for $50. Unilateral contract. You, however, are not bound to mow my yard. You have given me no promise to mow your yard, so that's why there is no obligation on your part, but there is an obligation on my part. And that's why we refer to it as a unilateral contract. Contracts can be classified by the level of explicitness. In an explicit contract, the terms are defined by the parties, usually in writing, but sometimes orally. A doctrine called the statute of frauds requires some contracts to be in writing to be enforceable. And we know that businesses generally favor explicit written contracts because it allows the business to minimize its risks. So when you go download a new version of iTunes and you go through the end user license agreement and you have to page through 42 screens of text, the reason why there is this long, lengthy, detailed explanation of the parties' rights and obligations is because the company involved is trying to minimize its risks. Now, another type of contract would be called an implied contract, in which the terms are implied by the party's behavior or through custom. And thus we can create a contract even though there was no explicit contract. If every day I'm a farmer and I sell fresh milk to the local grocery store, and I bring the milk by, and then they pay me for it. Over time, this behavior may create an expectation. It may create an implied contract. Now, courts don't like implied contracts because it's too open-ended. However, they do exist from a legal standard. So in conclusion, what did we learn in this lecture? Contracts allow businesses to protect their expectations and to manage risks. We know that a contract, in order to be valid, must meet certain requirements. Certain elements must be present. And finally, we know contracts can be categorized in different ways. Again, thanks for listening, and I'll see you in the next one.